So to the interns, this is what this looks like. And so what is on there is all the jurors' information. Usually attorneys can look at that and decide if they want to shuffle. And there's only one shuffle in a trial. So if the defense board requests a jury shuffle, the state can't come back and say, oh, I want to shuffle too. There's only one shuffle per trial. And the only thing it does is it rearranges the order in which the jurors come in. And you will find that when you do jury shuffles, it only moves people about two spots, but it's all random. Yeah.
I didn't.
Mm-hmm. Yeah, because sometimes people, they have different type of people. They look at their professions and they say, we want more professionals to try to be on the jury. So then they may ask for a shuffle to see if they can get them closer here. Sure.
Very good.
Yes. Mhm. Oh, yes, we're ready.
Number one, follow me.
Oh, and stand for the jurors whenever they come in. I'm not standing at this moment because I have to put something in the system.
Okay, sir, first row. And the chairs are numbered. Come on in, let's go.
I'm sorry.
That's what you get for being in the front. Have a seat. Thank you. 9. Second row. Number 15. On the bench. Twenty-two. Who's 22? Next row. Way at the end. 30. Number 30. You're pretty. Number 32. You're 37. Next row. Okay. 44. 43. 44. 51. 57. She made it to her chair, Judge.
All right, thank you. All right, everyone, please be seated. And everyone, just give me one moment, please. All right, everyone, good afternoon. Well, wait a minute, there is like no response at all. And since there's no response, that means that everybody wants to remain for the night shift here. So I'm going to try that again. Good afternoon. All right, welcome. You are in the 187th District Court. You're on the fourth floor, and I'm Judge Stephanie Boyd. So, what floor are you on? What's the court number? And who's the judge? Now, I know you're probably asking yourself, hey, why would she ask such a thing? We obviously know where we are because this is where we are. The reason why I always tell jurors that and ask that question is because whenever we take a break, what ends up happening is sometimes jurors want to go to the restroom, sometimes they want to walk around outside, and then they end up getting lost. We've had jurors before who've been on a panel here, and we're searching for them, and they're down the hallway trying to be on another panel because they don't realize they're no longer in the 187. So if you're ever lost, because sometimes jurors will tell me, I looked up and everybody was gone. But if you're ever lost, all you need to do is remember the 187. If you can't remember the 187, just remember the last name Boyd, because I'm the only Judge Boyd in Bexar County downtown at the courthouse. All right, so to my left is the court reporter. I always said if I were in a position to make somebody's job easy, I would do the best I could to make their job easier. I think everybody would like if their jobs were easy. Is that correct? So I want you all to help me make her job easy. One, she has to take down everything that everyone is saying. So if you can imagine, some people whisper, which do not whisper. Keep your voice at the same level or higher as my voice is. And don't talk over each other. I know sometimes we start talking and it becomes conversational, but she has to be able to write all of that down. And the worst thing for court reporters, if somebody is reading their writing and there's a lot of spaces where they write two people talking, because that doesn't make them look good. I always tell them I will write a letter for you and say that everybody was talking over each other. But that's not good for them. The other thing I'm going to ask you all to do, and no jury has been able to follow this instruction. I tell every jury, I have faith that you all can do it. So I have faith that you all can do this. The cards you have in your possession, everyone, please raise your cards. And do not lower your cards until I ask you to lower your cards. Everyone in the box over here, please lower your cards. Everyone on the front row, right here in front of me, lower your cards. If you still have your card raised, whenever anyone asks a question of you, or whenever you want to answer something, if you're able to, stand when you're answering that question, because the court reporter will be able to hear. The acoustics in this courtroom are not great. So can everyone promise me that if you're able to, you will stand if you have an answer for a question?
Yeah.
All right. So Cindy, we're going to see if that happens. That's never happened before, but hey, miracles happen. All right. You may lower your card. I'm going to allow the parties in this case to introduce themselves to you. This is the state of Texas versus Oscar Martinez. State, please introduce yourself.
Hi, my name is Daniel Escobar.
Good afternoon. My name is Hank Wilkins.
All right, defense, if you were introduce yourself.
Good afternoon, everyone. My name is Michael DeLeon. This is my paralegal, Felicia Garza, and this is my client, Oscar Martinez.
All right. Does anyone recognize any of those parties? If you do, raise your card. All right. And I know that you all have been waiting patiently in the hallway. I want you to know that your waiting out in the hallway in no way had anything to do with the parties here or with Mr. Martinez. It's just that every day I have a huge docket. So we have a docket in the morning, then we have trial. So it's neither of their faults. Does everyone understand? All right. Now, the charge in this case, there are 3 counts. Count 1, the charge is murder. Count 2, the charge is murder. And count 3, the charge is aggravated robbery. I'm going to come back and talk to you about those charges in a little bit. Nobody neither the state, the defense, or myself can tell you what they think the facts of this case are. So whenever the state or the defense asks you questions, they're going to be talking to you in hypotheticals. So whenever you're thinking about a question that they're asking of you, don't think to yourself, oh, this is what this case is about, because they're not allowed to give you what they think the facts are. The only way you will know what this case is about or what is happening in this case is if you are on the jury. Does everyone understand? Now, as you can tell, there are other people in the courtroom other than these parties. So sitting behind defense counsel, if you can introduce the parties behind you.
Yes, this is Mr. Martinez's mother and father and his grandmother.
All right, does anyone recognize any of those parties? All right. Now, the other thing that ends up happening is, I believe education is very important. So a lot of times we have interns who will come, law students, people who want to be court reporters, some other prosecutors, they will come and sit to hear what's going on. So that's the people who are to my left. Now, you may see people come through the exit door, that door. They're coming through that door because they did not read the sign that says, please do not enter this door. We're in a jury trial. That happens all the time. The people who come through this door are staff. It's not about this case. There are different orders that I need to sign. So they still will come in and do that. Does everyone understand? Okay. Now, how a case comes to a criminal court is by way of a criminal felony court is by way of indictment. An indictment is just a document that lets a party know what someone is accusing them of and where they need to be to answer for the accusation. Does everyone understand?
Yes.
All right, let's practice raising our cards. How many people in here have ever had a traffic ticket? See, I always suspected San Antonio was filled with bad drivers, and it is. There are a lot of bad drivers. Okay. All right, you can lower your card. So I've had one traffic ticket in my life. It happened when I was, I want to say about 18 or 19. I'm 21 now, so it's only been about 2 years. Hey, that's not that funny. So anyway, back in the day when I received a traffic ticket, that was when they had the little paper thing. They would sign it, tear it off, give you a copy of the paper. Now I think they do it electronically or something. I haven't had a ticket since then. So let's say you have a traffic ticket and the officer is saying that you ran a stop sign, that you didn't come to a full stop for the stop sign, and they give you a ticket and you accept that ticket. You're accepting that ticket. You're not saying you're guilty of it. The officer is giving you a ticket to let you know, hey, I'm saying you ran this stop sign. So when you go to a jury trial, you're going to know that what you're showing up for is because an officer is accusing you of running a stop sign. Does everyone understand?
Yes.
Now, how would you feel if an officer gave you a ticket for running a stop sign? You show up to jury trial and you're there not for running a stop sign. They just surprise you and say, oh yeah, you're here for not following through with the yield sign. That would be wrong, correct? Because you think you're there for a stop sign. So when you get that ticket, you're not saying you're guilty. It cannot be used as evidence against you. An indictment is the same thing. An indictment is just a document to tell you, this is what you've been accused of. This is what you're showing to court for. But it cannot be taken as evidence whatsoever against anyone who's accused. Does everyone understand? So is anybody going to hold it against Mr. Martinez that he's here under indictment? Now, the next thing I want to talk to you is the right to remain silent. How many people have heard of that term? All right, so I see my Beretta people, my Mannix people, my paper chase people, and the practice people. You can lower your cards. And the young people have no idea what I'm talking about, so that's our secret. All right, so I've been a defense attorney. I've been a prosecutor. When I was a defense attorney, there are a host of reasons why my client would not testify. Sometimes I would tell my client, look, there's no need for you to testify. The state hasn't proven their case. We're done. Then sometimes I would have clients who would be so nervous and sweating profusely. I would always say, that's not a good look. Maybe you shouldn't testify. Then I had some clients who had speech impediments, would stutter. There are a host of reasons why somebody may decide not to testify. Now, I know some people who've never been accused of a crime, they will say, well, if that was me, I would get on the stand and say something. I always call that the Mrs. Kravitz thing, where you just want to hear what's going on. Mrs. Kravitz from Bewitched. So, but in this case, a person who's accused of a crime has the guaranteed right to remain silent. Does everyone understand? And you cannot hold it against them if they decide to remain silent. What that means really is that if they decide not to testify, if you were deliberating, you can't say, well, you know what? They didn't testify, so that's a strike against them. You can't consider it, discuss it whatsoever. Does everyone understand? Is there anyone who's going to hold it against Mr. Martinez if he decides not to testify? Now, the next thing I want to talk to you is about presumption of innocence. Everyone who's accused of a crime is presumed to be innocent. You know what that means? That means that the state must prove a person in a criminal case guilty beyond a reasonable doubt. The burden never shifts to the defense. So if you're ever deliberating on a jury and you find yourself saying, well, the defense should have brought A, B, and C, you're shifting the burden. The burden always remains with the state, and the state has to prove their case beyond a reasonable doubt. Does everyone understand? Now, you may ask yourself, what is the definition of proof beyond a reasonable doubt? That is a perfectly good question. When I graduated from law school, you had to know that definition. I knew the definition forwards and backwards. I still know the definition. I know where to pause for dramatic effect. I know where to place the comma. My first jury trial, I used that definition. In my mind, I was like, don't mess it up. Don't mess it up. I said it perfectly. I had the jury trial. And then for my next jury trial, guess what? There's no longer a definition for proof beyond a reasonable doubt. So neither the state nor the defense can tell you what the definition is because there is no longer a definition. So when I was a prosecutor or a defense attorney, I would always say, how am I going to explain how high this burden is to a jury since we don't have a definition? So the way I would explain it to jurors is by telling them what it was not. Next door, the courthouse with the green rooftop, the historic courthouse, that's the civil courthouse. Over there, they have cases where you could be, your liability may be in the form of you having to pay money. For example, your car accidents. The burden of proof over there is preponderance of the evidence. More likely than not that something occurred. If you are ever on a jury trial in a criminal case and you're deliberating and you're in back and you're saying, well, I think it's more likely this occurred, or yeah, this probably occurred. You are not at the right burden of proof. You're at the burden of proof for civil cases. Does everyone understand? The other burden on the civil side in Texas, that's the highest burden on the civil side, it's what's called clear and convincing evidence. Clear and convincing evidence is the type of evidence that's needed to terminate your right to be a parent to your child. That means the government says you're a horrible parent, right? You're a danger maybe to your child, and we're not going to let you be their legal parent anymore. That's another burden. Proof beyond a reasonable doubt is a higher burden than that. Does everyone understand? All right. Now, I want to talk to you about fairness, because sometimes defense attorneys and prosecutors will ask you in cases, can you be fair? Because honestly, when people come down, a lot of times they're like, man, can I just get an accident case or can I get a drug case? I know none of you thought you would be coming to court to hear a murder case or any other type of aggravated robbery case or anything of that nature, but you're here. So people will say, can you be fair? Can you be fair? Nobody who walked into this courtroom today walked into this courtroom with zero life experiences. Am I correct? So some of us may have had traumas in our past. Some of us may have had other issues in our past. Sometimes the state will ask you, well, maybe your car was burglarized this morning. You get up, it's been burglarized, and you find out you're going to be on a trial involving a burglary of a vehicle. That's not maybe the trial for you. That's what people will say. That's not really the proper question. The proper question is, if you were on a jury trial for a burglary of a vehicle, knowing that your car was just burglarized that morning, would you be able to listen to the evidence that's presented in the case that you're in, you're going to be the juror on, and just make your decision if you can come to one based upon what you hear? It's the same thing with any other case. So in this case, there are 2 counts that are murder, 1 count that's aggravated robbery. The question is, will you be able to listen to the evidence that is presented? And if you're able to come to a decision, would you be able to base your decision upon the evidence that you hear in this case? Does everyone understand? So with that instruction, is there anyone here who cannot be fair? All right, that's number 1. Thank you. All right, now I want to talk to you about phases of jury trials. In Texas, there are 2 phases. First phase, people call it the innocence phase. It's really not the innocence phase. That's not the proper terminology that should be used for it. Phase 1 is, did the state prove their case beyond a reasonable doubt, or did they not? You will see sometimes on television where somebody is found not guilty, and the media will report it maybe as, oh, that person was found innocent. No, that person was found not guilty. The jury said the state didn't prove its case. That's phase 1. Phase 2, you only get to that phase if you decide that a person is guilty. Phase 2 is what's called the punishment phase. In Texas, anyone who's charged with a criminal case must decide if they were found guilty, who would decide their punishment? Would it be the jury or would it be the court? Does everyone understand? Yes. In regards to that, Mr. Martinez has decided that if he were found guilty, that he would have the jury assess punishment. Is there anyone who's going to hold it against him because he's decided if he were found guilty, the jury would assess punishment? Okay. Now, the next thing I want to talk to you is about ranges of punishment. In Texas, the range of punishment for murder is anywhere from 5 years to 99 years or life in prison. So what does that mean? Because that's a wide range. That means if you were to find somebody guilty of murder, you could sentence them to 5 years, 6, 7, 8, all the way up to 99 years or life. Does everyone understand? Now, what type of person maybe would you think of would be worthy of maybe 9 years, maybe 5 years, maybe life? Let me give you an example. Let's say you have sweethearts. They were in elementary school together and they would always joke, and their parents would joke, yeah, those 2 are going to end up getting married. They're high school sweethearts. They go to college, they graduate, they get married. They're together, they celebrate their 60th anniversary. Let's say the wife gets very ill and she's dying. You know, the doctors say, sorry, there's nothing we can do, but she's going to be in a lot of pain, but she'll probably be here for 2 months, but she's going to be suffering a lot. The wife begs the husband, please help me end it. Give me some extra pills. Well, if he gives her the extra pills and she takes them and she dies, or if he holds the water for her to drink, and if he feeds her the extra pills, that's murder in Texas. Now, in that situation, maybe that's a case. If you were to find that person guilty, you would say, that person probably deserves only 5 years because you're no longer eligible for probation for murder in Texas. Does everyone understand? Now, let's say you have the other person on the other end of the spectrum. The other person, the teachers would always say, man, he was always pulling wings off of butterflies, or she was always pulling wings off of butterflies. See a cat walking down the street, kicks the cat, knocking over garbage cans, and just constantly in trouble. And all the people in the neighborhood are afraid of them, right? That may be a person who if you were to find guilty of murder, maybe you say that person deserves life, or that person deserves 99. Does everyone understand? So with regards to the range of punishment for murder, the range of punishment is anywhere from 5 to 99 years or life. Would everyone be able, if you were selected on a jury, if you were to find somebody guilty of murder, would you be able to listen to the facts and consider that full range of punishment when assessing punishment? Is there anyone who will not be able to do that? Okay, that's 1, 5, 10, 11, 12, 15, 18, 20, 21, 34, 65, and 68. All right, range of punishment for aggravated robbery. Range of punishment for that offense is the same, anywhere from 5 to 99 years or life in prison. Does everyone understand? Okay, is somebody talking? I'm hearing feedback somewhere. Oh, okay, awesome, thank you. I was like, what, am I hearing things? All right, so the range of punishment for aggravated robbery is the same range, 5 to 99 years or life up in prison. Does everyone understand? All right, and also possibility of probation. Does everybody understand? All right, so again, here's the thing about that offense and any other criminal offense. It's just, will you be able to consider the full range of punishment if you were to find somebody guilty? Does everyone understand?
Yes.
And there are different scenarios where maybe you can think of, I would give somebody probation in this case. I would give somebody life in this place, or I would give somebody 20 years in this case. Does everyone understand? Is there anyone who would not be able to consider the full range of punishment in that case? All right, 1, 5, 10, 14, 15, 18, 20, 25, 34, 37, 53, 56, 64, 65, 67, and 68. Next, I want to talk to you all about languages. I love languages. I think languages are great. I wasn't supposed to be in Texas. I was supposed to be retired by now at the ripe old age of 21 and retired in Paris. I'm from Louisiana, so there was only one language for me to learn that I felt I should be learning, and that was French. My friend in school with me, she was, Stephanie, take Spanish with me. We can be in Spanish class together. I'm like, not going to need it. I'm going to need my French. So lo and behold, there were other plans for me. And now I'm in San Antonio thinking, why didn't I take Spanish? So I think languages are beautiful. When I was in college, there are people who spoke 6 different languages. One of my friends speaks 8 languages, and I am just in awe and thinking, why didn't I do that? But it's never too late. So is there anyone here and English is not your first language? Please raise your card. 5, 10, 36, 56, 62, 68, 71. We have someone late to the party, 47. All right, thank you. You can, and 40. All right, number 5, what's your first language?
Turkish.
Oh, wow.
From
That's
Istanbul.
new.
Istanbul.
All right. Have you been able to understand everything?
Not like 80%. That's why I just denied a couple of things because I didn't understand. I don't want to say guilty or not guilty. I don't.
All right,
I
thank you.
understand. I don't feel comfortable understanding and give somebody the guilty or not guilty.
All right,
About language. Mhm.
all right, thank you. Number 10.
That's me.
All right, what is your first language?
Spanish.
All right, have you been able to understand everything?
Most of it.
All right, thank
I
you.
can write it and read it, but listen and if they speak too fast, I might. I don't want to-
Como está? That's all I have. All right, thank you. Number 36. All right, see, we've already fallen off. I'm so disappointed in all of you. 36. All right, thank you. Have you been able to understand everything? Okay, 56. Have you been able to understand everything? Thank you. 62. Have you been able to understand everything? Thank you. 68. Have you been able to understand everything?
Yes.
Thank you. 71.
Spanish.
Have you been able to understand everything? 40. Have you been able to understand everything? 47. And what's your language?
Well, literal, all they spoke was Spanish in the house, but when I went to school, first I was speaking English, so I don't know if it's my first or not.
All right. So have you,
I understand it. I can understand English.
okay, awesome. Thank you. All right, so I'm gonna, the next question, does anyone have any time constraints or travel arrangements planned? You have tickets, you can't put in my name. All right. 2, 8, 12. Your cards turn backwards. 15, 31, 34, 21, 44, 48, 56, 65. 2, what's your time constraint?
Just sit for my neurologic written board exam at the beginning of next month,
All right, and when is that?
July 10th. Or June 10th, excuse me.
June 10th? I hope you've been studying.
The whole day, Your Honor.
Okay. Number 8? Yes,
I fly to Cancun on the 19th.
Cancun 19th. What are you doing in Cancun?
It's my best friend's 40th. Birthday party.
All right, who's all going?
All my friends from college for the girls trip.
Oh, okay. Y'all have fun. Number 12?
My sister's 75th birthday party, July 11th.
All right, and where is that? Minnesota. Hopefully the temperature is better there than it is here. Okay. Number 15.
Houston on the 22nd of this month, and then the 28th of this month, New York, and June 30th, Cape Cod.
Oh, look at her just traveling everywhere. And see, this trial is not even going through to the 28th or for her Cape Cod, but I think she just wanted us all to be jealous, but okay. Number 31.
I have a medical appointment on Friday,
What time?
4:10.
All right, thank you. 34.
Church active in the evenings, 3 days a week. I'm behind the podium.
All right, what time?
Anywhere from 6:30 p.m.
All right, thank you. Number 21.
I have a doctor's appointment tomorrow that can be canceled, but I am traveling the week of the 24th
All right, and where are you going?
to Florida.
What are you going to be doing in Florida?
Going to the seaside, right where all the sharks are right now.
Okay, well, hey, watch Jaws before you go.
Right?
Yeah. Number 44.
I fly out on the 4th of July to Orlando for a reunion,
Oh, what type of reunion?
Panama Canal Zone reunion.
Oh, okay.
The Canal Zone, we meet once a year, every year.
Okay, awesome. Is that where people show up and then people say, well, what are you doing now? And they're like, I'm the president.
Follow everybody.
All right. Thank you. Number 48.
Coincidentally, I will also be attending the high school reunion for Panama Canal Society.
Oh, wow. Do you,
Third through the seventh in Orlando, Florida.
oh, wow. Okay, thank you. Number 56.
Friday, I will be in Raleigh and then July 6th.
All right, so what are you doing in the Valley on Friday? For who? Do you really want to go to that? All right, thanks. Number 65.
We're not on the July 3rd.
All right, what are you doing in California? Okay, thank you. Number 75.
I'm gonna go to Oregon. Or
I'm sorry, you trailed off. You're gonna have to keep your voice up.
Oregon.
Oh, what college are you attending? Why is it not LSU? I see you, non-SCC person. All right, thank you. When are you leaving?
20th.
Of June? All right, thank you. Good luck. Number 73.
July 1925, I'm gonna be going to California with my little brother.
All right, what are you guys doing in California?
He just graduated, and so he wanted to celebrate graduating from high school.
All right, thank you. 74.
Doctor's appointment on the 17th.
And what time?
At 3:15.
All right. Yes, somebody didn't see any trap doors open, so now they're being brave.
About the dates, July 8th,
Oh, where are you going?
Colorado.
See, people just want to drop where they're going. What's the temperature going to be there? Yeah. So what are you doing in Colorado? And what date?
July 8th.
Okay. 37,
My cousin is getting married June 23rd.
June 23rd. And where? All right, so you're sitting down. See, I just lost faith, but okay. That's okay.
Yeah, very, it's pretty much like an all-day event.
When?
I believe that's Saturday.
June 23rd?
Sunday.
Are you in the wedding party? All right. No, I'm just asking because maybe you won't have to buy the dress. All right. Thank you. Number 17.
I'm starting schools, June 17th,
Where?
Paul Mitchell.
Okay. Oh, look at you. Paul Mitchell, the Paul Mitchell products. All right. Thank you. Congratulations. 68.
My son's graduating Thursday from high school at 9 o'clock in the morning.
And you just remembered that?
Oh, I don't know the time.
Okay. All right. All right. Thank you. All right. So I'm going to tell you all two stories. They're both true. I know that people find jury duty to be an inconvenience. And I say inconvenience, it's not a sacrifice. Here's where the inconvenience comes in. And I see this happen to people all the time. One, there are too many one-ways downtown and you get lost and you see the building and you're just thinking to yourself, if I could just turn to this corner, I'll be right at the building. And then the next thing that probably pops up in your mind, if I were to turn, would anybody notice? Would I be able to make it down this one way? Don't do that. Don't turn down a one way. The other thing is parking is expensive. If I could pay for everybody's parking, I would pay for everybody's parking. If I could have jurors get free parking, I would have them get free parking, but I'm not in charge of that. The other thing is I see people, they start running to the courthouse because you're supposed to be here at 8 and you don't know where you want to go. And I always tell people, slow down because you're going to hurry up and wait. So I know everybody hurry ups and waits. But for all of you all are here, raise your card if this is your second time being called up for jury duty. There you go. So you can lower your card. So your government only asks two things of you. One, to pay your taxes, and two, show up for jury duty. And they don't even ask you to come for jury duty every month. It's sort of like once in a blue moon. Let me just tell you what a sacrifice is. And I tell every jury this story. My uncle grew up in a small town called Grand Cane, Louisiana. My grandmother had 2 boys, the rest of them were girls. And Grand Cane is small town. It's even smaller now. So all the teachers knew everybody. They knew all their students. My uncle, who's since passed, was extremely smart. So the teachers would skip him to the next grade, skip him to the next grade, skip him to the next grade. He was one of the first people who knew about computers when they first started bringing out computers. He was very good with math, all of that. So anyway, he graduates from high school and the Vietnam War breaks out. So he asked my grandmother to sign up for him to go to Vietnam because he says, there's nothing for me here. I can't improve my lot in life, just staying here. Just sign for me. Now, mind you, that was my grandmother's firstborn son. And it's not like today where you have a computer, you can send emails to people. You had a television. My grandmother had one television, black and white. And for the young people, there were 3 stations. Really, you should say 2, because NBC was always iffy. You had to have the rabbit ears just right. It couldn't be windy at all. The weather had to be still. Otherwise, you're going to get lines. But you would have ABC, CBS. And now you have television. You can watch television 24 hours a day. Young people, back in the day, there was no 24-hour television. Your television would go off and you would know when it was about to end, because if you were doing things right and sort of on the cusp of the 70s, mid 70s, they would play the national anthem. The flag would start waving on the television and that's the end of programming. Or if you're a little bit earlier in life, it would just go off and you would just have white noise going across the television. The end. You have to wait till tomorrow for television. The phones. Not like you have today. I know some people don't even know what a rotary phone is. My grandmother did not have a rotary phone. She didn't have a push phone. She had the phone with no numbers on it. And you know why there were no numbers on it? Because you just pick it up, the operator answers, and you tell them what number you want them to dial. That's why you have the song Beechwood 45789, because that's the number they want it down. And as a side note, my mom said whenever the songs would come out with people's phone numbers in the song, they would always call the operator and ask them to dial their number. But so my grandmother didn't know anything about Vietnam. Like, where is this place? But she signed for him to go. And when she signed for him to go, she had an address for him. But it wasn't as though she sends a letter and she knows, the next day, oh, my firstborn son arrived. He's doing okay. So I bring that up to say that's a sacrifice. What we're doing right now, it's not a sacrifice. It may be an inconvenience for you because of the time frame, but guess what? It's very important to Mr. Martinez, his attorneys, is very important to the state because both sides want you 100% focused on that. And I think this is a small thing that your country is asking for you. Now, the state and the defense are going to get a chance to ask you some questions. In law school, and she and I are still best friends. I had a friend. She decided to do civil law. Nothing against civil attorneys, but criminal law attorneys, we're in court more than they are. Every day you're in court. You try more cases than they try. And so she got called up for jury duty. She said, let's have lunch. I'm like, hey, great. So we have lunch. And I asked her, how is, jury selection going? She's like, it's going fabulous. Now that I'm a judge, I'm like, how can it be fabulous? You were not with Stephanie Boyd. Okay, that should not be funny. You guys should be like, yeah, she wasn't with you. So I said, what do you mean it's going fabulous? She's like, oh, I'm not going to be on the jury. I'm like, why not? She says, it's just like when we're in law school. I'm on the back row keeping my head down. So I start laughing and she's like, what's so funny? I said, we're going to get to have lunch all week. So I say that to say this. One, she and I did start having lunch all that week because she didn't answer any questions and didn't speak up. So be engaging with the attorneys so they can learn about each of you and make sure that you are a good person for this jury. And remember, when they ask you about fairness, it's just really whether or not, if you were selected for this jury, could you listen to the evidence that's presented to you and make a decision, if you can, on the facts that are presented? Does everyone understand? All right, so the state and the defense are going to get a chance to ask each of you some questions. Before we move into that, is there anyone who needs a break? If you need a break, now's the time to say so. All right, so this is what we're going to do. I'm going to give you all a break. We're going to come back. I think 3:15 should be enough time for everybody. Is that correct? If you need to go to the restroom and you see there's a line at the restroom, all you need to do is find a stairwell. Wherever you see stairs, there's a restroom on either side of those stairs. And remember, what floor are we on? Who's the judge? And what's the number? All right, so you all can leave your items here. Make sure nobody would touch them. Make sure you leave your cards behind. And when one person leaves, everybody must leave. Look to your left, look to your right. You're responsible for that juror. All right, everyone, please rise. And also, everyone, if you make sure you get your parking validated. So if you have time, it may be good for you to go downstairs, get your parking validated so you don't have to wait till the last minute to do it. Okay. All right. Thank you.
Yeah.
That's what I'm like, absolutely. And, poor Mr. Brad. All right, everyone, please be seated. All right, and everyone, thank you for looking out for the juror to your left and to your right. We have all the jurors here. So please remember the previous instructions. If there's something you would like to answer, just raise your card and wait till the attorney calls on you. And again, if you're not in the box or on this front row, please stand if you can when you're answering questions to make it easier on the court reporter. So with that being said, I'm going to turn it over to the state. And after the state asks you some questions, the defense will have a chance to ask questions as well. State?
Hello there. First off, I'm gonna ask, can everybody hear me?
Yes.
Okay, if at any time, if you guys cannot hear me, please let me know. I know there's a microphone up here, so I'll use it if I need to. But as we introduce ourselves, my name's Daniel Escobar, and this is Steve Wilson. We work for the Bexar County DA's office, and we represent the state of Texas in criminal matters, okay? Now, a lot of my slideshow, funny enough, Judge Boyd already covered, so I'm gonna try and go through it a little bit quickly. So this part is jury selection. There are 3 goals. I'm going to teach you guys a little bit about the law so that you guys have a little bit of a basis in what we're talking about, okay? Second, I'm going to try and talk to you guys, start some conversations. I'm going to ask you questions. So I'm sorry if you guys have a little bit of stage fright, but it's a necessary part of things. Third goal is going to be to try and pick a fair and unbiased jury in this case. Again, it's the 2 questions. Will you be fair and impartial? And will you follow the law? And now Judge Boyd gave a great example. Again, if somebody had broken into your car and it shattered all the glass and you came in here for burglary of a vehicle, it's whether or not that experience would make you be unable to be fair and unbiased. So you're gonna hear me ask you guys that a lot. Sorry if it gets repetitive. Now, process is actually pretty quick. It's the jury selection. Then it goes into guilty, not guilty, where evidence will be heard. And then if we get to the next step, it's gonna be punishment. So the very first thing I wanted to talk to you guys about is murder. Can everybody see the screen? I'm probably gonna read off a good chunk of this right now. But there are 3 ways to charge murder in the state of Texas. First one, intentionally or knowingly causes the death of an individual. Pretty straightforward. I think everybody would have said that makes sense for how you would charge murder. The second one is intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. And I'll talk to you guys a little bit and explain what I mean by serious bodily injury, okay? The third one is commits or attempts to commit a felony, and in the course of and in furtherance of the commission or attempt, or an immediate flight from the commission or attempt, the person commits or attempts to commit an act clearly dangerous to human life that causes the death of an individual. Now, there's a lot of commit, attempt to commit. What does that really mean? It's were you committing a felony, and in the course of committing the felony or when trying to get away, did you do something that is clearly dangerous to human life and someone died? It's felony murder. And here's just an example of what we call the elements of the first section. Our elements are the things that we need to prove beyond a reasonable doubt. If it's not one of these elements, we do not need to prove beyond a reasonable doubt that thing. So we have things like the date, which prove when this happened. Bexar County, Texas, it had to have happened in Bexar County. If it happened in Travis County, it should be in Travis County. Defendant, we have to prove identity of who did what. Intentionally or knowingly, that's a mental state, and I'll explain that here in a second. Causes the death of an individual, right? So someone had to have died, it's murder. How the death was caused, we have to tell you guys this is how it happened. So again, that's that first section. Intentionally or knowingly causes the death of an individual. For an example, let's just say you take a gun and you shoot someone 10 times. You make sure they're dead. I think everybody would agree with me that you intentionally caused their death. Is there anyone who would disagree?
No.
Okay. Oh, let's see if technology work with me. Paragraph B. Again, the date, Bexar County, defendant. Intent to cause serious bodily injury. Defendant committed an act clearly dangerous to human life, cause the death of the victim. Okay. So again, that's the second portion that I showed you from that first slide. Now, again, I'll give you an example. Let's say you shoot someone in the leg and you hit an artery. People could still die from gunshot wounds to the leg. You intend to hit them in the body. You may not intend to kill them, but it's a bullet. You can't control where that goes if it leaves the gun. And as a result of your actions, as a result of you intending to cause serious bodily injury, they died. Again, that third one, date, Bexar County, defendant, intentionally or knowingly, commit or attempt to commit a felony. So there, you can attempt to commit a felony, but not be successful. Doesn't matter if you did it or not. If you tried, that's enough. While in furtherance of or immediate flight from or attempted commission of said felony. So it's either during the felony or as you're trying to get away after the felony. Covers that. Did or attempted to commit an act clearly dangerous to human life that caused the death of a victim. And again, that's that third section from murder that I was talking about earlier. An example, you're robbing someone, you're running away, and then someone tries to stop you, and you shoot at them, and you kill them. You may not have intended to kill them, you may have wanted to scare them, but you're committing a felony, and they died as a result of your actions. So I want to explain also briefly robbery. So a person commits an offense if, in the course of committing theft, and with the intent to obtain or maintain control of the property, you intentionally or knowingly threaten or place another in fear of imminent bodily injury or death. Breaking that down for you, you're trying to steal something, you're trying to maintain control of it or to get it, and you threaten someone. You say, I'm going to hurt you if you try and stop me. That's enough. Or you actually do hurt someone. That's also a potential option. Aggravated robbery, a person commits an offense if you commit robbery, if you're trying to do a theft, and then you threaten someone, but at this point, you cause serious bodily injury, or you use or exhibit a deadly weapon. Just to break that down, deadly weapon, the one that's going to come to most minds, juror number 20. What's a deadly weapon? What's one that came to your mind right now?
A gun.
A gun. That inherently is a deadly weapon. Is anyone here who would disagree with that? Right. So, serious bodily injury means bodily injury that creates a substantial risk of death, or that causes death, serious permanent disfigurement, or the protracted loss or impairment of the function of any bodily member or organ. Breaking that down for you guys, there's a good chance they could have died, they actually died, or there's some sort of loss that happens. I think you shoot someone's eye out, you take someone's hand, someone loses a leg, things like that. That's serious bodily injury. Does everyone understand? Okay. So definitions, intentionally or knowingly. So again, with intent, with respect to the nature of his conduct or to the result of his conduct, when it is his conscious objective, or desire to engage in the conduct or cause the result. You do something and you meant to do it, right? If I tell you guys right now, juror number 21, if I say, I'm going to pick up this pen, then I do this. What did I intentionally do? How could you tell? I said it. And I did it. You guys can all see it. You don't need to read my mind. Sometimes people do say that. It's a little weird to do that all the time, but it can happen. Knowingly, or with knowledge with respect to the nature of his conduct or to the circumstances surrounding his conduct, when he is aware of the nature of his conduct or that the circumstances exist, a person acts knowingly or with knowledge with respect to the result of his conduct when he was aware that his conduct is reasonably certain to cause a result. It's a lot, right? I'll do an easy one here. Okay? See if this will actually agree with me. Juror number 21, I'm picking up this pad. Okay. I intentionally picked up the pad, and for those of you who couldn't see, the pen was on top of the pad. Not that easy to do this demonstration when some of you guys can't see, but I picked up the pad, but what was on top?
Okay.
Right, so I knowingly did it. I knew by picking up the pad that I would pick up the pen. Simple. It's not rocket science here, it's common sense. There's a third one, it's recklessly. That one is that you know that your action can result in something, but you do it anyway. What I mean by that is, let's say I took a pen, turned around, and just tossed it into the crowd. Now, I don't know for sure that my pen's going to hit one of you in the eye, but I just said that I kind of already knew that that could happen. So that's recklessly. You know that it could happen, but you do it anyway. You have disregard for the fact that it could. Does that make sense? I just wanted to touch on that one just because that's another mental state that could occur. This is how you prove intent. As juror number 21 said, it's words and actions. You can look at what someone says, look at what someone does, and you can infer and say, well, I believe that you intended to do this. I know you knowingly did something. It's not something that we're trying to ask you guys to divine or to figure out, and it's going to be difficult. Sometimes people make it a lot more obvious than they intend to. I just want to touch on really quickly the burden of proof. The state, we bear the burden of proving this case. The defense doesn't have to prove the thing. Mr. DeLeon, I know in law school there's an example that professors will use, but the defense attorney can fall asleep at the table. They don't have to do a thing because it's all on us, and that's a burden that we gladly take on. The defendant can choose not to testify. We can't make him testify. He has that choice, and you guys can't hold that against him. Beyond a reasonable doubt. It's not beyond all possible doubt, not beyond a shadow of a doubt. It's a reasonable doubt. I'll break that down just a little bit easier. A reasonable doubt, it's a doubt that goes towards an element of the case. So if it doesn't apply to one of those elements, if you doubt something that doesn't apply, it doesn't matter. And it's reasonable. Possible is not always reasonable. Just because something could happen doesn't mean that it's reasonably that it happened. Okay? So first scale question, what I'm going to do is probably go section by section, and I'm going to say who would agree, raise your card, who would disagree, raise your card. So kind of look over the question. It's if you believe all elements beyond a reasonable doubt, you would be able to find the defendant guilty even without knowing the motive. There's a reason why I'm asking that, because in the elements that were listed on those slides, the one thing that never came up, why? We don't have to prove why anything happened. We just need to prove that it did. Does that make sense? So take a second. I'm going to start with this section. Starting with this section, who's the number one? Who agrees with that statement? If you believe all elements beyond a reasonable doubt, you would be able to find the defendant guilty even without knowing the motive. So you do not need the motive. Raise your cards just so and I'll call out the numbers, and once I call your numbers, you can roll your card. 4, 5, 6, 7, 8, 9. You can roll your card, man. Thank you. 12, 13. Okay. Who's the number 2? They disagree with that. That if they believed all the elements beyond a reasonable doubt, they would be able to find the defendant guilty even without knowing the motive. That they disagree with that. That they'd say, I need the motive in order to make a decision. Please raise your card. Okay, I'm going to count it out. 1, 2, 3, and then 10, 11, 14. Thank you, guys. Let's do this one. I'm going to start with these first 2 rows, and we'll just go with who disagrees with that. That if you believe all the elements beyond a reasonable doubt, you would be able to find the defendant guilty even without knowing motive. You disagree with that. Take a second and please raise your card. 15, 17, 18, 19, 20, 21, 22, 23, 24, and then 29. All right, the next 2 rows. You disagree with that statement. Take a second and then raise your card. Okay. 33, 34, 36, 30, 39, 40, and 43. Okay, thank you. Now the next 2 rows. You disagree with that statement. If you believe all the elements beyond a reasonable doubt, you would be able to find the defendant guilty even without knowing the motive. And again, this is you need the motive in order to find someone guilty. Please raise your card. 45, 47, 48, 50. I think I missed 35 earlier. 52, 53, 54, 55, 56. Okay. Now I'm going to go to this section, first two rows. You disagree with that statement that if you found all the elements beyond a reasonable doubt, you met all the elements beyond a reasonable doubt, you would still say, I need the motive. Who disagrees? Raise your card. 60, 62, 63. All right, I'm going to do the next three rows just so that we get all the way to the end. Disagree with this statement. If you believe all the elements beyond a reasonable doubt, you would be able to find the defendant guilty even without knowing the motive. Next three rows. 65, 67, 68, 71, 72, 73, 74, 75. All right, thank you. Now, there's generally two ways to prove that someone committed a crime. First off, it's physical evidence. Now, when you guys are thinking of that, I'll be thinking something like CSI, and in some cases it can get cool like that. But oftentimes it's fingerprints, it could be shell casings, it could be video, it could be plenty of different things that physically come into the trial, and you guys can consider that. The second thing is witness testimony. If someone gets on the stand, if you're on the jury, can listen to what they say. And you can make a determination as to their credibility. You have to say, do I believe what this person is saying? And oftentimes it's, does the witness testimony coalesce? Does it agree with physical evidence? That's oftentimes they kind of work in unison. You can't do one without the other. Doesn't make sense if all the physical evidence doesn't make sense with what the people are saying, right? So I just want to cover very quickly, because this comes up often in cases, is justifications or defenses. So what this is, it's a defense to prosecution. You have to claim self-defense. Now, what I mean by that is that you have to actually say, yes, I committed the crime, but I did it for XYZ reason. That has to come out at some point. You can't just say nothing and then at the end say, well, self-defense, guys, come on. There has to be some evidence to come in. So just definition, a person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. Now, just to break that down, you have to have a reasonable belief. It can't, and I'll explain what that means on the next slide. That has to be immediately necessary. If someone says, I'm going to kick your ass in 2 weeks, you can't then attack them and hit them and say, I was defending myself. It has to be necessary in the moment when you act. And again, to protect the actor's use, to protect the actor against the other's use or attempted use of unlawful force. So if they're the ones that you're attacking them and they hit you, that's not unlawful force on their part. They're defending themselves. Words alone don't matter. You can't say something to someone, or someone can't say something to you. You attack them and say, well, I was just defending myself, guys. You have to actually be meeting that force with force, not force with force. Does everyone understand? Reasonable belief means a belief that would be held by an ordinary and prudent man in the same circumstances as the actor. It's not whether or not the actor thought that they were acting reasonably. It's this reasonable man, and I think you guys are all probably reasonable. It's, can you put a reasonable person in that person's shoes? What would they do? Would they have acted or not? That's the question. Common sense. So just to cover, it's a reasonable reaction, equal force, immediately necessary, words alone are not sufficient, and you cannot provoke the difficulty. You can't start the physical altercation and then later say self-defense, self-defense, self-defense. If you're the one that throws the first punch, you cannot claim self-defense. Does everyone understand? Yes. Now, we have to go further on to the deadly use of force, or use of deadly force. A person is justified in using deadly force if you meet all the requirements of self-defense. You have to get past that part. If you don't get past that part, you can't use deadly force. Makes sense. When and to the degree the actor reasonably believes the deadly force is immediately necessary. again, going back to reasonable belief and immediately necessary in that moment, to protect the actor against others' use or attempted use of deadly force. You can only go to deadly force if you think someone's using deadly force against you. You have to match fire with fire. You can't bring a gun to a fist fight. Okay? Or to prevent another's imminent commission of aggravated robbery or kidnapping, sexual assault, robbery, and murder. That second probably makes sense. If you're getting robbed, yeah, you can use deadly force. If someone's trying to sexually assault you, yes, you can use deadly force. Those specific crimes, you have the ability to do it. So going back, cannot be against a future threat, must be immediately necessary, cannot be brought on by words alone, cannot provoke, reasonable reaction, it's got to be a last resort. And it's, again, we're asking common sense. You have to think about these situations. Now, this portion, self-defense with deadly force. So, it's presumed that it's reasonable, or one of the prongs to presume that it's reasonable is that someone wasn't committing a crime. If you're committing a crime, it's difficult for you to use self-defense. It's not impossible, though. You can still claim self-defense. But if you're committing a crime, it makes it more difficult. You don't get a presumption that it's reasonable if you're committing a crime. And that makes sense. If someone's committing another crime, it's not supposed to be easier for them to say, well, I was just defending myself. It's a facts and circumstances. It's something that people who are on the jury could possibly have to make a determination on. The law of parties. We'll get into the fun part. So I'm pretty sure everyone here has seen a bank robbery movie. Raise your card if you haven't seen a bank robbery movie before, if you have not. Right? They're fun. I always wanted to be the wheelman in a robbery situation, not to actually do it, but to just drive a car real fast and try and get away. So let's take an example of the bank robbery. There's two guys. One of them has a gun, one of them has a car. The guy with the gun goes into the bank and robs it, ends up with a bunch of money. And he runs back outside and meets the wheelman, the getaway driver. Now that getaway driver drives away. My question for you is, who here believes the getaway driver is just as legally culpable as the guy with the gun? Now, please, if you disagree with that, read that statement and raise your card. Again, they're working together. They're both trying to rob the bank. They both want to rob the bank. They're working together. Who would say that the driver is just as legally culpable as the person with the gun entering the bank? I'll start with this second. Who disagrees with that? Who says, I don't think they're the same, or I don't think he should be held just as legally liable? Okay, juror number 7. And what I would also want to distinguish is I'm not talking about how much punishment they should get. The question is more towards, should they also be held as responsible for what happened in that bank robbery? That's what I'm asking. And juror number 7, you'd still raise your card? Okay, juror number 7. I'll start with the first 2 rows here. Who disagrees with that? They're like, the getaway driver, I don't think he should be held responsible for the robbery. He didn't have the gun, he didn't go in. Raise your card. Okay. Juror number 15, 18, 19, 23. Thank you. Next 2 rows. Again, you disagree with that. You're like, I don't think this getaway driver, he did nothing wrong. Next 2 rows. Who thinks that? Who would disagree with that statement up there? Got juror number 39 and juror number 43. Okay. Thank you. Next 2 rows. Who disagrees with that statement? Please raise your card. Okay. Gonna go over here. First 2 rows. Who disagrees with that statement? Please raise your card. Okay. Next 3 rows. Please raise your card if you disagree with that statement. I got juror number 72. Okay. Again, I'm not trying to convince you guys of anything. I just want your opinions, and I appreciate it. Thank you. This is where we're talking about the law of parties. A person is criminally responsible as a party to an offense if the offense is committed by his own conduct or by the conduct of another for which he is criminally responsible, or both. You can be held responsible either through your own actions, the actions of someone you are criminally responsible for, or both. You do a mix. Now, talking about criminal responsibility, that's also defined. A person is criminally responsible for an offense committed by the conduct of another if, acting with the kind of culpability required for the offense, he causes or aids an innocent or non-responsible person to engage in conduct prohibited by the definition of the offense. What that means is, if you intentionally or knowingly do something, and that causes someone to do something where intentionally or knowingly, like we mentioned earlier, is a part of it, they have to have that intent, that knowledge of action, then you can be held responsible for what they do. I'll give you guys an example. I've seen a couple of those videos where it's people on YouTube where they go around pranking people. Who are seeing those videos, right? Everyone's kind of nodding around. You guys have heard of that. Well, what happens if someone comes up to a person with a fake gun, points it at them, and tries to rob them? And then that person that they're trying to prank shoots them, or shoots one of the other people that there. It's a group of them. He kills one of them. Well, you intentionally and knowingly tried to get him to do it, or tried to get him to react. You intentionally did it. No one forced you. And as a result, he intentionally or knowingly used force, defended himself. He thought it was real. Everyone will understand that makes sense. If you make someone do something intentionally, and it could be a possible outcome, that's the result you're left with. The second way is acting with intent to promote or assist the commission of the offense. He solicits, encourages, directs, aids, or attempts to aid the person to commit the offense. That covers our bank robber. If you're trying to help him out, guess what? You're responsible for what he did. That's the law. If you try and get him to, hey man, let's go rob a bank, guess what? You're responsible for what he did. If you direct, if you encourage any of those things, if you did that, and if you actually did it, you did help, you're responsible. Now, additionally, if in the attempt to carry out a conspiracy to commit one felony, another felony is committed by one of the conspirators, all conspirators are guilty of the felony actually committed, though having no intent to commit it if the offense was committed in furtherance of the unlawful purpose and was one that should have been anticipated as a result of the carrying out of the conspiracy. Breaking that down for you. If you're trying to do one felony and someone commits another felony while it's happening, and it's something that you could have seen that coming, should have known that this was going to happen, that it's very realistic that it's going to happen. Well, guess what? You're responsible as well for that other felony. It attaches to you. Who here disagrees with that? Who here doesn't like that? Is there anyone here? Juror number, what's your number, sir? What do you think about that? If you're committing one felony with a bunch of people, and then one of the other people does something that you should have seen coming. Do you like the fact that the law reads like that you could be responsible for what someone else could do?
Yeah.
Okay. Now I'll get into it a little bit here. Conspiracy means an agreement between two or more persons to commit a felony. Hey, let's go rob a bank. That's a conspiracy. It's enough. Now, doesn't have to be as explicit. It could be you're hanging out with people. You all get your guns, you all get your ski masks. Say, hey, let's go to the corner store, see what they got. You can get to that point without having the talk of, let's draw out the contract for our robbery. You don't have to have that airtight of an agreement. And it can be before, during, or after. It could be in the lead up to what's happening. It can be while it's happening, and even after it's happening. So, in a murder, if all elements are met, however, the person on trial was not the shooter, could you still find someone guilty of murder? Now start with this section. In a murder, if all the elements are met, however, the person on trial isn't the one who actually shot that gun, could you still find that person, or would you be able to find that person who didn't shoot guilty of murder? Raise your card if you couldn't. Could not. All right, and I'll call out the numbers and you guys can go over or whenever I call them out. 1, 3. Could you? And again, if you can't find, if you cannot find guilty, so cannot. Okay, 1, 3, 11, 13, and 14. Okay, this section. You could not find someone
Can you repeat the question?
Sure. If in a murder, if all the elements are met, however, the person on trial was not the shooter, but they were part of the conspiracy, you could not find them guilty of murder. They didn't pull the trigger. Please raise your card.
All right, and just 1 second, let me pause you just 1 second. All right, everyone, if you'll lower your cards, here's the law. And let me give you a hypothetical. Let's say I'm sitting with someone and I know hypothetically that there's a convenience store and that convenience store is going to have a big payday. And I know at midnight, they're going to have $20,000 in the safe when normally maybe they only have $200. So I talked to a bunch of my friends, and let's say I talked to Jane and Susie. I say, Jane, Susie, this convenience store is going to have a lot of money at midnight. Now, do y'all want to go in there and let's take that money from that person? And everybody sits around the table and everybody's agreed. Yep, we're going to go in, we're going to rob that convenience store at midnight, and this is when they're going to have the big payday, right? And so there's a person who has to drive to get us there. They're like, I'm a good driver. You know, everybody's seeing Transporter. You have somebody who's the driver, right? And that person, if the police show up, they can drive, they can get you out because they're a good driver. Then you may have somebody who's the lookout. And I tell Susie, Susie, you don't wear glasses like me. Your vision is perfect. We're going to need you to look out and make sure nobody's coming. And Susie's like, okay, I got you. And then let's say another person comes along. They said, Stephanie, I can crack that safe in case the person who has the key or the combination won't open it. So we all agree. Every one of us is going to get a percentage of that money when we pull this off. And then I tell everybody, and you know, there may be trouble. So I'm going to bring a gun. And that way, if there's trouble, I can use the gun. Everybody agrees on that. So the driver drops us all off at the convenience store. Susie's the lookout. I get there. The person don't want to open the safe. That's fine, because guess what? We have somebody who can crack the safe. They crack the safe. Somebody comes in unexpectedly and just say, I shoot them. Does everybody have that hypothetical? Well, the law says that if I shoot that person and that person dies, that's a murder. It may end up being a felony murder. Everybody is responsible as though they shot that person. And the reason why the law says that is because guess what? If we didn't have the driver to drive us there, how are we going to get there? If we don't have Susie for the lookout and we think she's a big part of that, how are we going to commit the crime? If I don't have the person who can crack the safe, how are we going to crack the safe? And if I don't have the gun to shoot somebody in case somebody needs to be shot for us to complete this enterprise, then all of this never would have happened. Does everybody understand? So the law says, if you are the driver, if you're the person who's looking out so that the crime can be committed, everybody's responsible. So even though that person is the driver, it's like they walked in that convenience store with the gun. Even though the person is the lookout, it's like they walked into the convenience store with the gun. Even though the person who's only there to crack the combination on the safe, it's like they walked in there with a gun, because everybody is working together so that we can get the $50,000. Does everyone understand? So when it comes time for punishment, people may say, well, that person was just the lookout. Maybe we're going to give them a different amount of time than the person who actually shot. Does everyone understand? So the law says everybody's responsible. You understand? All right, State.
Thank you. And the judge makes a good point. It's similar to kind of what I was talking about here. And I'll go into an example because guess what? The judge pointed out to a really good one. Now, in this example, two people go into a convenience store to attempt a robbery. Both of them pull guns and both of them take the money from the convenience store. Who here feels that both robbers are criminally responsible for the ag robbery? This section, raise your card. Okay. Again, I'm gonna just ask this entire left side. Raise your card if you agree with that. Okay, how about this side? I'm pointing to the right. Is there anyone here who disagrees with that statement? That if both of you guys pull out guns, you go to that convenience store, you take money, you're both just as responsible. Example two, two people go into a convenience store to attempt a robbery. Both of them have guns. One of the robbers shoots and kills the clerk while on the commission of the robbery. Is there anyone who feels that the person who did not shoot is not criminally responsible for the clerk's death? I'm changing it up from what the slide is. You feel that the person who did not shoot isn't responsible for the clerk's death. Is there anyone here who would say, I don't think he's responsible for what the other guy did? Raise your card. Okay. Gonna go here on the left. Who'd say, I don't think he's responsible as the guy who did shoot? And again, it's whether or not you think that, just as the judge mentioned, it's whether or not you think he should be held to the same responsibility, not the same punishment. Okay, I'm gonna count it down. 15, 23, 24, 27, 33, 34, 36, 39, 40, 45, 47, 48, 52, 53, 54, 55, 56. You go to the right side. You don't think that the guy who didn't shoot is as criminally responsible. You don't feel that. Raise your card. Juror number 72. Is there anyone else? And 73. Thank you. I'm gonna go to the third example. Two people go into a convenience store to attempt a robbery. Only one of them has the weapon. The one with the gun shoots and kills the clerk. Who here feels that the person without the gun is criminally responsible for the clerk's death? Raise your card. I'll start with this left section. And again, you feel that they are equally responsible.
Equally.
Not equally, shouldn't be equally punished. That's another question. It's equally responsible. Okay, I'm gonna count it down. 1, 4, 5, 6, 7, 8, 9, 11, 12, 13. Gonna start with these first two rows. Who here thinks, yes, they are equal, they should be responsible? Yes, ma'am. What's your juror number?
I'm 32.
Juror number 32.
Does the person without the gun know the other person has the gun?
It's an interesting question. I would say yes, because they're both attempting the robbery. They know what they're going for, and we'll assume that they both know he has a gun. Okay.
They can't assume that.
Well, I'm saying,
Just said, oh, no, we're not using guns, they got a fake gun, the guy who has a gun, the guy's like, I didn't know.
well, let's assume for just this hypothetical that they both know it's a real gun. They both know he has it. So I'll start with this first two sections. Who could hold the person without the gun criminally responsible? Who can? Raise your card. Yeah, I got juror number 18, 19, 20. You can.
Okay, Ken,
Can.
he's asking, how many people can hold the person responsible?
Okay, and then take a second and raise your card. 16, 19, 20, 21, 22, 25, 26, 27, 28, and 29. All right, the next two rows. Who can hold both criminally responsible? And just the next two rows. 30, 31, 35, 37, 38, 39, 40, 41, 42, 43. Again, the question is can hold both of them. Can. Next two rows, raise your cards. 44, 46, 47, 49, 50, 51, 55, and 56. All right, gonna start over here, the first two rows. Who can hold them responsible, both hold them responsible? 57, 58, 59, 60, 61, 62, 63, 64. Okay, final three rows. Who can hold them both responsible? 65, 66, 67, 68, 69, 70, 71, 73, 74, and 75. Thank you. We go on to the next example. Two people go into the convenience store to attempt a robbery. Only one has a gun, and they both know that the guy has the gun. But the clerk pulls out his own gun and shoots the robber who had the gun and kills him. He's getting robbed. He pulls out a gun. He shoots him. Who here feels that the surviving robber is criminally responsible for the dead robber's murder? Because his murder, he intentionally killed him. Who here feels that the surviving robber should be held responsible for that dead robber's death? I'll start off with the section. Who feels that they should be he should be held responsible?
Judge, can we approach?
Yes.
I'll change it up. Who here feels that the surviving robber should not be charged for the dead robber's murder? Who here feels that the surviving robber should not be charged for the dead robber's murder? Please raise your card.
Should not.
Should not. I know I'm changing it up on you guys back and forth, but keep you guys awake.
Should
Should not be charged.
So the person that was getting robbed.
No, so what I'm talking about is the robber who survives.
Oh,
They should not be charged for the other robber's murder. Yes, juror number 13.
Okay, my question is, I don't know the law on that.
So what? I'm,
If it was what she was explaining.
so again, the law is that if in the course of committing one felony, another felony is committed. And a part of that party language is, again, if you intentionally cause someone, or knowingly cause someone to commit an act, and it's a violation of the law, you're also responsible for that violation of the law. So you're causing the clerk to kill your co-robber, but at the same time, you're surviving it because you intentionally tried to rob them. Does that make sense? It's again, felony murder. You're trying to commit a felony and another felony, due to your actions, is committed. Okay? So who here feels that robber should not be charged? The one who got the loot.
Gray area.
Yes, just one
Can we
second.
approach again?
All right, the objection will be sustained.
Well, who here feels it's a gray area? Juror number 12? Why do you feel that?
Well, on the reverse, I think that both robbers are responsible for killing, maybe the clerk. But in the case, I'm not so sure that the second robber should be responsible for the other robber's murder. That's gray area.
And again, I'll explain because part of the, that part of it is that it's the anticipation. Could he anticipate that could happen? That's the question. If you're robbing someone, can you anticipate?
Well, in that case, then, yes.
So who here after that thinks this is a gray area? After what juror number 12 said? Is there anyone here? Okay, juror number 3 and 11. Thank you. I'll start with these first two rows here. Who does think it's a gray area? Juror number 15, explain, why do you think it's a gray area?
Because even though based on the law, they would be on, because they filed an intent on crime. But in the same situation that it's just a view, that's not the question. The question is the question of law. So.
And I understand, and we'll go away from what the question is up there, okay? So what I'm asking is it, from what you're saying is that, can you anticipate that would, is that kind of where your hang up is?
Yes, and that technically you can't anticipate on what's gonna happen in the situation. And you don't know if and I know these are all assumptions and we're going to based off of that, but you really can't, assume that the, I guess, clerk would have a weapon. And so going in.
And that's fair. I guess, what would make you think, okay, I can anticipate that this is gonna happen? Is there anything there? What if there's a sign that says, hey, there's a gun, we have a gun in here?
If there's like, of course, if there's like a sign, of course, then you're gonna be like, more than likely they're gonna not rob. Someone will not go in there because they know there's a gun there, but you can't anticipate.
So based off of what you're saying, so is it that, because you can't anticipate like everything that could happen? That's why you're like, oh, it's a gray area, I don't know. Is that a good? Okay. And who here would agree with juror number 15? Okay, they can anticipate. Okay, who here would, sorry, juror number 32?
Okay. You're
All right, please stand so the court reporter can hear.
It is a murder. The court shoots person.
Right, and I'm trying, right now, we're just keeping it, we're keeping it just to the robbery at this point. So just on the robber, focus on just the robber, guys. Juror number 31?
The survivor did not have any kind of force on him.
As in, he didn't use any force against the clerk?
He didn't use any force against the robber, against his partner.
Right, and who here would agree with, and sorry, so raise your card, that the fact that it's that he didn't use any force against his co-robber that makes you guys hesitate. But, and again, part of what, when explaining the law is that, does it make sense that you can say, you're in essence anticipating what could happen? And I know you guys are all thinking, well, we're not fortune tellers, we can't anticipate what would happen. Who here thinks that it's unlikely that a clerk would possibly have a gun whenever they go to rob the clerk? Who here thinks there's no way that clerk has a gun?
I don't even think the gun is the issue. I think it, based on what you said, I think it's a fair reasoning to believe if you're gonna attempt harm on someone, that they're going to try to protect themselves.
Right.
So they don't even have to have a gun. It could be any other form of protection. So,
Right, and
so I think that goes against what you were saying, because it's reasonable to expect someone to defend them.
thank you, ma'am, juror number 12. And again, juror number 48.
But as I understand it, correct me if I'm wrong, I'm confused, you're saying that, okay, two guys go in, one guy has a gun, clerk shoot the guy with a gun,
Right,
the surviving guys are down to his death.
yes. And do you agree or disagree with that?
Right, that's all, I just want
No, and did that clarify it for anyone, right? I think, because we're trying to talk about it, I'm just trying to get y'all's opinion, and thank you, sir. Juror number 49.
Hello, I feel like it's a technicality, because it. Look at the other side of the law, if you don't mind, I don't want to confuse people. Say there's two police officers going through a situation, they don't know. And one gets shot. Would the officer be charged?
And juror number, can you hold up your number?
He's not committing a crime.
And again, number one.
Same thing. In this case, they're both guilty. You know, when you go with somebody in a robbery, you have intentions and anything could happen. You
And-
really know that.
Who agrees with juror number 30? That when you go on a robbery, you know that anything can happen. I think that's everyone. And that's kind of what we're cutting into here. It's the fact that could you, when you're robbing someone, you may not know 100% what they have, but can you guess that there's a chance that they could? It could happen. You don't have to be perfect. Juror number 55.
I think some of the confusion, at least for me, comes from the question when you say feel. Because you can feel personally that we shouldn't be held responsible. Like, what's our responsibility as jurors? Is to go by what we feel is fair, or like the definition of the law. We oppose that.
So just to talk about your responsibility as jurors is to listen to the evidence and to apply the law. The reason why I'm asking for you to feel is that I don't want to commit you to, are you going to say this if this happens? And I'm trying to say, well, what are your feelings about it? What do you think about it? And so both sides can have an idea.
I think that the law is fair, but at the end of the day, like, that's the law. And, you know, our responsibility, I guess, in that case, is like, okay, is this the law that they violated? That the point of that was given. That's
And I think you just hit the nail on the head, because what I'm trying to get at is, are you going to be fair and unbiased and apply the law? And then I guess the question is, are you not going to be fair and unbiased? That's kind of why I'm asking the questions. Juror number 21.
Sorry.
Yeah, sorry, I keep
Looking
just
at your
standing directly in your way.
notes. First, you said two people, they go in with intent.
Right.
It says only one had a gun. It didn't say whether he exposed that gun or not, so that's confusing to me. And then you said the clerk pulls out a gun and shoots the robber who has a gun, so did he, I guess he saw that gun?
And that's fair. Again, it's kind of hard just because on these, it's a lot of facts that you're trying to throw at somebody and make it a general thing to where everyone
Well,
can
I
kind of.
mean, they can go in there with intention to rob. But what if they change their mind and all of a sudden the convenience guy shot him?
I guess then that's kind of more of a question of at what point did they get to? Because if
Right.
they go in and they just say, never mind, let's just leave, they didn't commit a robbery.
Right, so what if he shot him and?
Well,
shouldn't- I mean,
I guess at that point, the question would then be, did the clerk have a reasonable belief, going back to self-defense? Was it a reasonable belief that a robbery was happening? If someone just went into a gas station, and just had a gun in the back of their pocket, well, I mean, open carry in a lot of areas. I don't know if necessarily that would violate the law. That's something that's another question. But just because you have a gun doesn't mean that you threatened anybody with it. Could be a police officer that goes into that store with a gun. You know, just, is it reasonable that the clerk's gonna say, oh my God, a gun, and then shoot him? It's kind of
All
what I'm trying
right,
to
so
get.
everyone, his example, don't add any facts to the example. Let me give you an example. Two people, and I'm gonna just break it down. Two people. Don't add anything to this fact pattern. They decide they're gonna rob a convenience store. One person has a gun. They sit down at a table, they say, we're gonna rob this convenience store. And number two person say, okay, I'm gonna bring a gun in case there's trouble. They go into the convenience store. They rob the convenience store. Person number two has the gun. Yeah, he thinks the clerk is getting a little jumpy. He pulls out the gun, he kills the clerk. The law is this. Both of them plan to rob that convenience store. Doesn't matter whether person one had a gun or not. Person number one went in that convenience store with person number two. Person number one knew person number two had a gun. There wasn't, hey, nobody bring any guns to this robbery of the convenience store, right? Everybody knows person number two has a gun. The law is they are acting in concert. They are parties. It is like person number one shot the gun. Is everybody able to follow the law that person number one is responsible, whether they shot the clerk or not? Person number two shot the clerk, but they're both responsible as though both of them shot the clerk. That's the law. Is there anyone here who cannot follow that law? The other scenario, number one and number two going to the convenience store. Number two say, don't worry, I have a gun in case things get out of control. This is the law. They go in. Number two pulls the gun intending to shoot the clerk. He's a bad shot, or maybe he doesn't get to pull his gun fully to shoot the clerk. The clerk see that number two is pulling the gun to shoot. Clerk beats him to it. And guess what the clerk ends up doing? Maybe the clerk shoots number two survives. He shoots number one dies. Guess what? The law says that those two people who went in that store, number two who survived is responsible for number one's death. Does everyone understand? Is there anyone who cannot follow the law? All right, there you go.
No, keep your cards up. Juror number three, and then we'll go to this side. Juror number 23, 24, 27, 45, 54, and 33, and 56. Thank you. And then on this side,
And what was the other one? I'm sorry, I didn't get the last one on that side.
56. And then on this side, it's juror number 64 and 72. Thank you. Okay, I always like adding more complication to it.
No problem. 10 minutes.
Even though an actor is justified in threatening or using force or deadly force against another, if in doing so, he also recklessly injures or kills an innocent third person, the justification of self-defense is unavailable in prosecution for the reckless jury or killing of the innocent third person. What that means is that if you're reckless in how you're doing this and you hurt someone else, so if you're the clerk and you're reckless with it, because again, as juror number 21 was asking, it's like, well, what's reasonable? She was acting about several facts. Let's say that the clerk, he didn't see them pull out the gun. They never once said anything about a robbery. They're just in the store. He just thinks it's a robbery, but he's unreasonable about it. He's being reckless with it. Well, at that point, he can't use self-defense. If it's just two people in the store and you just shoot them and you have no real reason, there's not a reasonable man in that situation would not have done that. You cannot claim self-defense. You're being reckless with it. Is there anyone who would say, I cannot follow the law in that instance where, even though he was being reckless with it, at that point, I still think he should get self-defense? Is there anyone here who would say that? Again, the requirement is you need to be reasonable about it. If you're being reckless, that's not where you can claim it. So in that circumstance, two people go to a convenience store to attempt a robbery. Only one has a gun. Again, they both know that the gun's there. They both are agreeing to go rob that store. Robber with a gun points the gun at the clerk. He says, give me all you got. And they're both participating in this robbery. It's not as if one of them's just standing there. Oh my God, I didn't know you weren't going to do that. They both know. Clerk pulls out a gun and shoots at the robbers. He's being reasonable. There's deadly force being used against him. And then at that point, he's responding with deadly force. He's able to do that at that point. Said the clerk is a bad shot. And accidentally, the bullet goes through a window and kills a bystander. Now, again, due to the law of parties, that clerk is acting in self-defense. It's the question of whether or not he was reckless. That's that question. And when you're faced with a gun, is it reckless to shoot back at someone trying to rob you? No. It can happen, though, that unfortunately bullets do travel further than that. But the question I have is, again, who here would think that the robbers should be held responsible? That the clerk responded to deadly force, and in using deadly force back, there was someone that was innocent that was hurt. Is there anyone who thinks that the robbers should not be responsible for that other person? Raise your card. Is there anyone? Okay. Juror number 15, what are you thinking?
Because once you pull out a gun, like you were saying earlier, you don't know where the bullet's gonna go. So if even though he's acting in self-defense, once you pull that gun out and you start shooting, you can't guarantee where the bullet's gonna go.
And that's true. And that's a very important gun safety tip. Juror number 30, and you can stand up, sir.
The thing is, if you go in there with a gun, you're gonna, yes, you're gonna be responsible. He had to draw his gun because you came in with guns, so it was an accident. He would have never shot or got his gun out had somebody else came in to rob him.
Who here agrees with that? That if they hadn't to come in and robbed, none of this would have happened. That, again, it's because they pulled out the guns that we're here. Is there anyone who would disagree with that? Disagree with what juror number 30 said? Juror number 68?
I disagree because when you take a job as a clerk, either you're gonna get some training because you know what can happen, a robbery, number one. And if you don't know how to use a gun, you should be trained not to take out a gun and try to.
And I would agree with you.
Give them the money.
I guess my question to you is, do you always know that they're not gonna do anything to you, even if you give them the money? You don't know. Is that fair?
It's fair, but you can try to talk to someone, and try to de-escalate.
Is there anyone in that situation? Thank you, sir. Is there anyone who would agree that you have to try and de-escalate? Raise a card. Juror number 36, 48, 50. Sure, and what's your juror number, ma'am?
61, I'm sorry.
Sure.
I work at a convenience store and training for that is computer based and there's no way, we're not prepared for something like that. We have a panic button. There is no firearms in the store. So if someone comes in, there's not much we can really do.
Right.
If they're coming in the store and someone's getting hurt, whether it's the clerk, the bystander, or one of them, that other person should be responsible for it, I feel.
Okay, thank you, ma'am. Juror number 58.
I don't think it should be on the clerk to really de-escalate because it has been happened before that they've given up the money, but then still been killed over it anyways. So it was rather them or the other one. Rather have them protect themselves than be killed.
And who here would disagree with juror number 58? He was saying that, again, at that point, it's you or them. And de-escalation may not be possible. So I'll move on really quickly.
3 minutes, 45 seconds.
I'm gonna change this one more time. We'll talk about that first situation, but now, does anyone's opinion change if the person that they're robbing is a drug dealer?
Yes, sustained.
Is there anyone who disagrees if if the person they're robbing is somehow doing some illegal activity? That the person they're robbing is doing something illegal, but they're still robbing them. Is there anyone who would say, well, you shouldn't be able to defend yourself?
Yes.
I'll boil it down to this. Is there anyone who thinks that because you are committing a crime, you cannot defend yourself? Is there anyone here who believes that? Because you are committing a crime, you cannot defend yourself. If you are committing a crime, you can't defend yourself. Is there anyone who would agree with that? Again, if someone's coming at you and you're committing a crime, you cannot defend yourself anymore. Is there anyone who would say, yeah, he can't defend himself? And
Can you explain a little bit better?
so, again, let's say I am committing some sort of crime. I'm stealing, I'm selling stolen goods, something that you know I'm selling stolen goods. And someone comes into my house and tries to attack me to get my stolen goods. Am I able to defend myself? I have the stolen goods, but can I not, if someone tries to hurt me, am I not allowed to try and protect myself? No, it's just someone completely different. It's not the person I stole it from, nothing connected to that. It's just someone's trying to come at me for what I've stolen. It's not the person who I stole it from. Am I not allowed to defend myself? Juror number 14?
The question saying that I can still defend myself rather than what I'm doing.
Right. That no matter what you're doing, you still could potentially be defending yourself. Okay. Who agrees with juror number 14 that it goes both ways, that you should be able to defend yourself? Who agrees with that? Okay. Who disagrees with that it doesn't go both ways? Juror number 2. Then I got juror number 20, 21. Is there anyone else on this side that it does not go both ways? Sure, juror number 55.
And this is under the assumption already that you're not in the process of committing a crime.
And the crime's already been committed. I have the stolen goods. That's already done.
I'm robbing someone and then, they go to shoot me and I say self-defense, I shot you back.
Right, because you can't, yeah, not that situation. I'm already at home.
It's not self-defense if you're in the process.
Exactly. You can't be the one to provoke the action. You can't start it. Is there anyone on this side that disagrees with what he said, that it goes both ways, that even though you're committing a crime, you should still be able to defend yourself?
Using agree or disagree?
Disagree. He says if you're committing a crime, you can't. And again, I know that's one of those things that get more complicated. Try to use the I had stolen goods and you take it.
All right, time.
All right, thank you guys.
Thank you.
Thank you all.
All right, defense.
Your Honor. Yes, moment.
Okay, sure, no problem. Oh, no.
Good afternoon, ladies and gentlemen. Before I start talking, why don't we all stand up and stretch real quick, because I'm gonna be talking for a little bit. Stand up, stretch. There you go. Appreciate y'all being here. And have a seat. All righty, thank you so much, folks. Folks, my name is Michael DeLeon. I'm gonna be representing Mr. Martinez here, and today we're gonna talk jury selection, right? All right, so we all know a little bit more about you now. Let me let you know a little bit more about me. I've been practicing criminal law for 24 years. For 18 years, I was on this side of the table. I was a prosecutor. 3 years with Fort Bend County District Attorney's Office, 15 years with the Bear County District Attorney's Office. All right, then I was an elected county court law judge. I was a domestic violence court judge. And for the past 2 years, I've been doing criminal defense. All right. Born and raised here in San Antonio, graduated from Medicine High School, UTSA, South Texas College of Law, and here we are today. All right. This case is important to me. I like what I do. I want to do a good job in this case. And at the end of the case, if for the 12 or the 14 of you who are going to be on this jury, I want you to say, you know what? He did a fair, reasonable job. All right. In this case, it's very important to Oscar here. Oscar has been accused of murder and aggravated robbery. All right. We're going to go through all of that. His freedom is at stake here. All right. His life is at stake, and he's been waiting for this court date for a very, very long time. All right. This is the only time you and I and the prosecutors get to talk to you. All right. Once you're seated into the jury box, the jurors just listen to the lawyers ask questions of the witnesses. All right. Jurors don't get to ask questions of the witness. Doesn't happen. Okay. There are no right or wrong answers right now. If this was a DWI case, you could say, you know what, Michael? Golly, 1 drink, 2 drinks, and you're getting arrested for DWI? That's crazy. All right. Or you might think with the DWI laws, there's way too many drunk drivers on the road. Police can't even get all of them. All right. The laws have to be stricter. That's your belief about the law, DWI law. And right now, we're just looking for your opinion when we talk about murder and aggravated robbery. Okay. We, as the prosecution said, we just want to pick a jury that's fair to both sides. Now, as you are well aware, we're not talking about the facts of this case. All right. We're talking about the law and legal concepts. Bias and prejudice. We all have bias and prejudices. Okay. If I was a juror or a potential juror and the defendant was a Dallas Cowboy, I'm not going to find him guilty. All right. Because, you know, the Dallas Cowboy, 5-time Super Bowl champion Dallas Cowboys are awesome. All right.
Yeah.
That's all right to have a bias. That's all right to say, you know what? I might not be the right case on the right juror on that type of case. Okay. So if you have a strong preference, I'm going to ask you a little bit. If you have a strong feeling here, maybe you're not going to be the right juror for this particular case. And it's okay not to serve. All right. Like we talked about before, if this was a burglary of a vehicle case and your car just got broken into last night, you might not be the right juror at this time, okay, for this particular case. As the judge stated to you, if there's a phrase at the courthouse, if you talk, you walk, meaning those jurors who raise their hand, who participate, and tend to not be on the jury because you say something or you raise your hand to something that this side or our side doesn't like, and then we get rid of you, okay? It's the quiet people, the ones who didn't say anything objectionable, then you get onto the jury, okay? Jury summons. What did y'all think when you got the jury summons? You're like, oh, no, it came. Here we are. So when you got up here to the basement, okay, you got up to the 4th floor, you got outside the door, you figured out this is a criminal case. You walked here into your particular seats and you looked over here at Oscar and you go, I wonder what he did, right? Sure, it's human nature. It's human nature to say he must have done something to get himself in this position, right? But in this country, every citizen who's accused of a crime, bless you, is innocent unless they're proven guilty beyond a reasonable doubt, okay? So that applies throughout the United States, through Texas, through Bexar County, everywhere, okay? And the concept of innocent unless proven guilty comes from the Constitution. It comes from common law, from the Magna Carta. It comes from all kinds of different legal sources. Here's my fear, though. Okay, you hear the allegations on this case. You hear that there's a death involved, right? Given your strong, I mean, everybody should have a strong feeling about that. They go murder, ag robbery. That's not good. Nobody is saying murder or ag robbery is a good thing. They're not saying it. We're not saying murder and ag robbery is not a good thing, okay? But in this particular situation, we need to figure out, are you, because remember, Oscar here is innocent unless he's proven guilty beyond reasonable doubt. So starting out, he's innocent, okay? I need you all to be able to understand the concept that, are you gonna hold it against him right from the very start? Like, there's already one strike against him because they accused him of murder. They accused him of aggravated robbery. Does anybody feel like, and raise your cards if you do, you're going, look, I'm already leaning a little bit towards the state versus the defense, even though the law is he's innocent unless he's proven guilty beyond a reasonable doubt. Anybody feel like they're already starting out with a strike against Oscar? On this side, number 1, number 6, 7, 12, 15, 24, 27, 32, 33, 34, and 22, I think. Actually, 22, 37, 38, 45, 48, 52, 53, 64, 65, 72, and 75 in the back. All right. So Oscar has a constitutional right to a fair trial. Once again, if you can't give him a fair trial, that's fine. It's just a matter of telling us, all right? Was anyone here ever a teenager? Yes, everybody here was a teenager. I looked at our chart. I think we only have 2 18-year-olds here in the jury panel, but we all remember being teenagers, right? Sure. And some of us either have teenagers or we were, of course, once teenagers at one time. Do teenagers always make the best choices? Everybody? No, teenagers make terrible choices sometimes, right? And that's just part of growing up, all right? Teenagers make bad choices, some more than others, obviously, okay? Who made decisions here as a teenager that, looking back, you would regret, or you say, you know what? If I could have done it over again, I wouldn't have done that. By a show of cards. Should be almost everybody raising your cards going, that was something. Fair enough, thank you. Teenagers can lie. They can cheat, they can steal, they can hang with the bad people, wrong crowd. They can do alcohol, drugs, maybe pick up a DWI. All right, they might have had a bad boyfriend or bad girlfriend, or cheat on the boyfriend or girlfriend. Bad choices, Sometimes teenagers and adults, frankly, can do something absolutely stupid. And does anybody disagree with that? All right, that people can do things that are stupid and not the best choices. Of course, we're all human beings. Now, so I want to talk a little bit about marijuana, very generally, okay? Just to touch on some things. Does anyone feel like marijuana, we know that marijuana is pretty much legal in California, Colorado, that type of thing, maybe some other states. Here in Texas, having marijuana is illegal, okay? That's the law. All right, does anyone feel like marijuana, though illegal in Texas, should be completely legal here in Texas? Anybody feel that way? Raise your card if you do. Okay, about half the group. Fair enough. Fair enough. I thought that might be the response. Does anyone feel like marijuana should remain illegal, except for maybe medical purposes? I think we can kind of agree that marijuana has some medical benefits for the right people, okay? So raise your card if you feel the law should remain the same. About half the group, right? Okay, fair enough. I just want to touch on that. Let's talk a little bit about law parties. The state talked to you about law parties. So they essentially need to prove that a felony was committed, all right? And during the course of that felony, a person dies, all right? Sometimes it's referred to as felony murder, all right? Now, mere presence during the offense of murder is not enough. There has to be, I'm going to kind of summarize, because you heard the language from the state. There's a lot of different legal language mumbo jumbo out there. But essentially, there needs to be a plan or a scheme, something that helps facilitate what eventually amounted to a murder, okay? So, we talked about convenience stores, didn't we? For a long time. Yes, all right. Facts matter, all right? Evidence matters. And here, we can't talk about the facts of the case right now. But when the state was talking to me about convenience stores and the clerk and robbing and going in and who has a gun and who doesn't, it all depends. The facts do matter. And for the 12 or 14 of you who are gonna be on the jury, you're gonna eventually hear facts and be able to get concrete facts to figure out the scenario that you need to figure out if somebody's guilty or not guilty of murder or aggravated robbery. All right, so the Judge Boyd here is the judge of the law. All right, the 12 of you who are gonna be in the jury box here are gonna be the judges of the facts of the case. Judge Boyd does the law, the jury does the facts. You determine what the facts are. That's your job as jurors, okay? Now, right now, you haven't heard any evidence right now, okay? You don't. But you know that, well, let me ask you this way. Who knows that even though you haven't heard any evidence right now, you just can't be fair? I know I asked that question before, and for those of you who raised your hands, we appreciate it. But does anyone else want to add to that and say, you know, I didn't raise my card last time, but, you know, after listening a little bit more, there's no way I could be fair in this case. Anybody who did not raise their card previously for that same question? Maybe juror number 20, 33, 30, let me go back, 18, 19, 20, 33, 34, 39, thank you, sir, 53, 56, 59, anybody else? All right, thank you, folks, appreciate it. So the state has the burden to prove that a citizen who's accused of a crime is guilty beyond a reasonable doubt. The defense doesn't have to prove anything to you. As Mr. Escobar stated, I could go and just fall asleep in my chair and not ask a single question. I'm not going to do that, but I could. And really, the state has the burden to prove this case to the jury beyond a reasonable doubt. All right. Now, south of the border, that might be a different standard where a person has to prove themselves innocent. All right. But here in Texas, in the United States, the defense has no burden. The state has to prove the case to you beyond a reasonable doubt. So what does that mean? As Judge Boyd was saying, there is no legal definition. The courts and the legislature have determined that you get to decide if the case has been proven to your satisfaction beyond a reasonable doubt. You come up with that definition, okay? Let me tell you what it is by looking at other things, okay? If you look at the very bottom, reasonable suspicion, if you are driving with a broken tail light, the brakes aren't working, you didn't turn a signal, you ran a stop sign, that gives a police officer reasonable suspicion to pull you over, all right? Permission to pull you over. He has reasonable suspicion, okay? And when he pulls you over, okay, probable cause is the next standard. An officer needs probable cause to arrest you for an offense. All right, so let's say you had the non-working brake light. Officer comes up to you, he smells alcohol, your eyes are red, you're slurring your speech, you get out of the car, you're stumbling around. It sounds like driving while intoxicated, right? The officer can arrest you if he has probable cause to determine you're violating the law like DWI. Okay, preponderance. Now, another standard above that is preponderance. That's your car wreck cases, your divorce cases, anything where you're fighting for money, okay? If one side proves the case a little bit more than the other, that means that they win. 51% versus 49, they win. So when an 18-wheeler goes and hits you in a company car, whatever language Thomas J. Henry talks about, you know, they have to prove it by a preponderance of the evidence, just a little bit more than the other side, all right? Above that, Judge Boyd talked about for the state to take away your parental rights, to take your children away, has to be proven by a standard of clear and convincing evidence. All right, pretty high standard. I mean, it's a serious situation if you're a bad parent and the state has to take away your parental rights. It has to be proven by clear and convincing evidence. But above that is beyond a reasonable doubt. That's the standard in every criminal case, from your first-time DWIs to a marijuana case, up to a felony such as murder, bank robbery, that type of thing, capital murder with a death penalty, all has to be proven beyond a reasonable doubt. All right? And here's my good question for you. Will you all agree to hold the state to their burden of proving the case, if you're on the jury, of proving the case beyond a reasonable doubt? All right, raise your cards if you can agree to that. If you're gonna hold the state to the burden of proving the case beyond a reasonable doubt. All right, almost everybody. All right, put your cards down, folks. And who disagrees with that? They're not gonna hold, and let me show you my next slide. Does anyone feel like they're gonna lower the burden because, hey, there's a death involved in this case? You know, I'm not gonna do beyond reasonable doubt, but if the state does clear and convincing evidence, or if the state does preponderance, that's gonna be enough for me to find somebody guilty because a death is involved. Does anybody feel that way? Raise your card.
I have a problem with just the definition. I know that's up to us, but
Sure.
I just don't. It needs to be convincing that with evidence that, I guess that's reasonable.
The law is it's gonna have to be beyond a reasonable doubt. Do you think you can do beyond a reasonable doubt? It's hard to know, right?
Yeah.
Well, I hear your hesitation. That's fine. We just needed to know. Somebody else raised their hand, the card over here, didn't they? 68. Thank you, sir. Appreciate it. Let's talk a little bit about that. Going back to you, sir. If the 12 of you who are on the jury, you might say statements like, well, maybe he did it, or probably he did it, or the state hasn't proved it, but come on, you know, there's a death involved. Or, you know, let's send a message to other people. You know, if you kill somebody and forget the evidence part, somebody's dead. Somebody's got to pay for it. See, right there, that's not beyond a reasonable doubt. If there's guessing here, like maybe he did it, probably, it has to be proven beyond a reasonable doubt. Do we all understand that? Okay. Anybody got questions about that? All right, let's talk. So why is this so important? Why am I talking about beyond a reasonable doubt so much? Well, our system is flawed. All right, but because human beings are involved in the criminal justice process. But our justice system in the United States is the best system in the world. All right, even with its flaws, it's the best system in the world. So beyond a reasonable doubt is the highest standard to avoid wrongful convictions. Have anybody heard in the news about wrongful convictions before? Raise your card if you've ever heard that. Almost everybody. That's good. Okay. Because there are situations where people who've been in prison for 10 years, 20, 30, 40 years, and then they find out they're actually innocent. They've been exonerated of the charge because of DNA evidence or something happened to where evidence was left out of the case or something like that that shows that they were actually innocent. Those things happen, okay? Because our system is flawed. But, you know, that's why jurors have to go by that standard of beyond a reasonable doubt. So we try to avoid as many wrongful convictions as possible. So innocent unless proven guilty. Does anybody disagree with that premise? I think we've talked about it enough. Thank you. Let's talk about the jury process. So once we pick a jury today, the 12 and 14 who are coming back tomorrow morning, we're going to start with opening statements. All right. Testimony begins. The state's going to put on their case. The state has the burden to prove the case to the jury beyond a reasonable doubt. I have the opportunity to cross-examine witnesses that the state calls. Okay. Once the state goes through all their witnesses, they're going to say state rests. And then the defense can put on a case if we want to, but we don't necessarily have to, because remember, we don't have the burden. We don't have to prove anything. All right, the state has to prove the case beyond a reasonable doubt. But we might decide to put on a case. We'll talk about that a little bit more. Then we go to closing arguments, all right, where we summarize what we believe the evidence showed. All right, now the jury's going to decide if Oscar here is guilty or not guilty and for what charge. Okay. If the jury comes back with not guilty on all the charges, everybody goes home. Case is over. If the jury finds Oscar guilty of one or more charges, then the jury has to do punishment in the case. All right. The jury needs to come up with the proper punishment. So let's go back to the defense putting on a case. We've all heard of the Fifth Amendment, right? Right to remain silent. The judge talked about that earlier. The So after the state's arrest, the defense can put on a case if we wish to, but we don't have to, because we might feel like the state didn't prove their case, and we're gonna argue that to the jury. Oscar could testify in this particular case. We don't know, because we have to figure out how the state's case proceeds, all right? But if Oscar doesn't testify, the court's gonna instruct you that you cannot hold it against him in any way whatsoever, all right? Why would a citizen who's accused of a crime not testify? Anyone? Anybody? Why would a citizen who's accused not testify? Ms. You don't want to incriminate yourself? What else? All right, what else?
That's a good reason.
I'm sorry?
It's self-incrimination. I mean, you don't think that's.
Self-incrimination. What else we got?
Inability to communicate.
Inability to communicate. Why is that?
They have difficulty getting out.
Sure, because if you're gonna be testifying here from the witness stand, you know, if Oscar's testifying from this witness stand, you might be nervous. You might be incredibly nervous. Your life is on the line here. And once I ask the questions of Oscar, the state gets to ask questions of Oscar. Highly trained prosecutors who know cross-examination, they're gonna get to question him. So, you know, he might be nervous, he might be scared, he's not good at public speaking. He's not a professional witness. Police officers might get on the witness stand all the time, maybe a firefighter or EMS or medical people, they might testify pretty routinely and not have a problem testifying. They might not get nervous, all right? But for Oscar here, who's young, he might say, geez, I might not do a good job up there. And Judge Boyd was talking about, you know, a potential witness, you know, sweating and looking all freaked out. They might not be the best witness up there, okay? So if a client chooses not to testify, will you as a juror hold that against him in reaching a verdict in your case? Let me say the question exactly. If you're on this jury and the defendant does not testify, Judge Boyd's going to tell you, you cannot hold it against the defendant if he does not testify. Would anybody here say, if I'm on the jury, the defendant doesn't testify, I'm still going to hold it against him? Anybody feel that way, even though the law says you cannot hold it against him? Number 23, 24, 59, 60, 64, 65, 55, 33, 34, and 37. Okay. Knowing that the judge is going to instruct you, you cannot hold that against him. Does that change anybody's mind? You raised your card. Anybody? No. Okay. Let's talk about witnesses. Credibility of the witnesses. As the jurors, you are the judges of the credibility of the witnesses and the weight to be giving their testimony. All right, like we talked about before, the judge determines the law, you determine the facts. The judge you heard from this morning in the basement, who was that judge, by the way? Was there a judge that you talked to in the basement? Okay, what was the judge's name? Nicole
Yes.
Garza. All right. She probably said her name about 10 times because she's going to be up for re-election one day. And she wants you guys to memorize her name. Most of you failed at that. Right? And describe what did the judge look like this morning? Your back. Is anybody kind of cute shoes? Good thing. That's a good thing to look for. Does anybody else remember the pearls? Yes. Yeah, a lot of people do. Okay. Sounds good. The reason why I ask this is witness perception. All right. If you look at the picture there, okay, see that? So what was that? What did we see up there? What did we see? A Yankees fan. Okay. What else?
Mustache.
A mustache. What else? A gun. Somebody saw a gun. What color was the gun? Anybody think the gun was a different color than black? Gray. We got some grays out there. Okay. Was anything about the hands of that person? Gloves. Did anybody not remember gloves? Anybody not remember gloves? Okay. Was he, what kind of shirt was he wearing? Dark, okay. Long sleeve? Was it a jacket or a shirt? Jacket, okay. Lots of different things, right? Let's go back to the picture. So, all right, is that mustache fake? Yeah. Now that you look at it, maybe, right? Because you might look at this guy for a brief second or two or three, right? Might not get every single detail, but he's got gloves, he's got a gun. Is that gray? Is that black? It's kind of, yeah, one of those gray areas, right? You never know. He's got sunglasses on. So there's a lot of different things that we perceive this. So when it comes to eyewitness testimony, sometimes it can be unreliable because you have a chaotic situation going on, all right? Or there's memory contamination. Somebody, you might be talking amongst a group and so suddenly somebody else's thoughts about things kind of become your thoughts, all right? Or there can be a time delay. Do you remember things better that happened yesterday versus 3 years ago? Right? You might remember things better that happened yesterday versus 3 years ago. Sure, that's just human nature. Okay. So credibility of the witnesses, once again, you're the exclusive judges of the credibility of the witnesses and the weight to be given their testimony. So what does that mean? As the jury here, you get to listen to the witnesses up here, and you can say, I believe everything that witness says. I believe some of it, not necessarily all of it, or I don't believe a word of it. That witness is lying to us. That's your job as jurors. You determine the credibility and the weight to be given the testimony. All right. Police officers. Are all police officers perfect? No, they're human beings. All right. Most of them are out there to do a wonderful job and to protect our community. All right. Will you believe a police officer and not evaluate their work? And said another way, if you're a juror here, will you treat police officers like any other witness and not give them brownie points right from the beginning? Like, if I see a police officer up there, I'm just going to believe everything that police officer says because he's a police officer. Or will you evaluate it and go, well, maybe that police officer has every intention of doing things correctly, but he's a human being. He or she might get things wrong. Fair enough. Does anybody disagree with me about that and go, no, I'm going to give, if a police officer gets on the witness stand, I'm giving brownie points right from the very start. Anybody feel that?
I would say I would just tend to believe him more because of all his training and
Because he's a trained
experience.
observer.
Sure. Yeah. And you might.
But I also knowing that he is fallible.
Absolutely. You, as a juror, you listen to the police officer. You go, you know what? He's got training and experience. Everything seems like he did correctly. Then you can believe everything he says. That's your job as jurors. Okay. Or you might listen and go, well, golly, it sounds like he might have messed up this little thing, that little thing. Are you telling me you would still go, no, he's still a police officer, I'm
No.
fine? Yeah, right? Makes sense. Okay. We're on the same page. So throughout the trial, I'm going to do objections. All right. I will object in this trial. Lawyers object about a number of things. Most of them are simple things, like an ask and answer question, a hearsay. That person's not an expert in what they're trying to testify to. Because remember, it's a question and answer format during the trial. Lawyer asks a question, witness gives an answer, and they go back and forth, back and forth. All right. So is anyone going to hold it against my client here, Oscar, if I object during the trial? Anybody feel like I'm going to hold it against? All right. Thank you, folks. So hearsay, that's an objection that happens pretty often. Hearsay is, it prohibits witnesses from testifying as to what other people told them to ensure that people testify only to what they observed firsthand. All right, let's do an example. Here, let's say Albert and Bert are talking and Albert says, I saw David stabbing his wife. All right. And then Bert, I think I named him Bert. Bert goes and testifies that Albert told me that he saw David stabbing his wife. That's hearsay because you heard it from a second source. All right. So it's kind of human nature though. And we go, let me tell you what I know about this situation. And I heard from this person told me this, or that person told me that. That's hearsay, so that's an objection right there, okay? It's evidence based on information received from another. In this particular situation, it would be Albert who needs to come and testify to what he observed firsthand. So punishment, let's talk about that. Yes, you're 48.
So you're saying that what Bert said would not be taken into account?
No, because he heard it from Albert, who Albert's the correct witness to come testify as to what David did. It's kind of like, it's kind of like, I heard from the TV that they said that certain person is guilty of murder. Okay, and it's like, well, I'm hearing it secondhand. That's not the best evidence. The witnesses who saw the murder or who can testify to some fact, they're the ones who need to come testify. Otherwise, it could be, I don't know, you can get anybody to come up and say, I heard this, that this person says this. Okay? Did that answer your question?
No, because you said best evidence, which is evidence.
Sometimes evidence, like hearsay, is inadmissible. Yeah, so there's rules involved. And in that particular scenario with that chart that I had up there, that's inadmissible. It's hearsay. So you can't say what somebody else said.
And ladies, think of hearsay in layman's term, it's gossip. That's what it is. It's gossip. Does everybody understand?
So instead of saying objection, gossip, I say objection to hearsay. Okay? It's well, as the judge told you, before you all come up to the fourth floor, all right, and this goes to every citizen who's accused of a crime in the state of Texas, they have to elect in the event that they're found guilty, whether they want the judge or the jury to do punishment, okay? In no way is anyone conceding guilt, all right? This is a procedural matter, has to be done before you ever come up to the fourth floor, all right? So, in this particular case, we have elected to go to the jury in the event that Oscar's found guilty of one or more charges, all right? But once again, we're not conceding guilt in any way, all right? Let's talk about punishment ranges. So, you might say this is kind of putting the cart before the horse. Why are we talking about punishment? In the end, we might think on our side, Oscar be found not guilty of all the charges, then punishment won't matter. But we have to talk about this because it's not like if the jury finds Oscar guilty, then we have to pick a whole new jury for punishment. No, the jury has to do it all, okay? So we have to talk about it now, just in case we get to that part of one or more counts of guilty. So as the court and the state told you, murder is from 5 to 99 years or life in prison. All right, aggravated robbery is once again a first-degree felony between 5 to 99 or life. And I need to know if you can consider the full range of punishment in this particular case. All right, it's a big stretch, all the way from 5 years up to 99 years or life. Okay, huge, wide range of potential punishment. It depends on the facts. And right now, we are not asking, what are you going to do in this particular case? Because you don't know any of the facts of the case. As the judge was telling you, an example of somebody who's been married for many years, the wife is dying of a very painful death. Pills are given over to help facilitate a death so she doesn't suffer. Is that a 99-year or life case? Probably not. Okay, that's probably more your very low end of the 5 years. Okay, so that's what we're looking for right now, just to keep an open mind. And once you've determined what the facts are in this particular case, if you get to a guilty verdict, then you're going to have the necessary information you need to make the correct call about what the punishment should be. Ag robbery, same punishment range, first-degree felony, all right? But if in this particular situation, if the murder charges were found to be not guilty, all right, but guilty of aggravated robbery, then if it can be shown that the defendant has never been arrested in this state or convicted in this state or any other of a felony, he can apply for probation from the jury. All right, so now the punishment ranges from probation all the way up to 99 years or life. All right, so big, wide range of punishment. All right, so anything's possible in that situation. Can everybody agree, though, that you're gonna keep an open mind, wait to hear all the evidence if you're on the jury, and then, you know, once you have everything in front of you, then you can consider everything from probation up to life in prison. Anybody disagree with that? Disagree. There's just no way you could consider 99 years, or there's no way you could consider probation. It all depends on the facts, right? Facts are important. Does anyone here work in law enforcement, related to someone in law enforcement? No, a prosecutor, no, an investigator. Raise your cards if you do, so hey, not too many. Let's go through that. 1, 2, 3, 6, 8, 10, 11, 7, 14. On this side, 19, 20, 23, 26, 27, 30, 34, 43, 44, 48. On this side, 59 and 63. For those of you who raised your cards, does anyone feel like, because I know that person who's in law enforcement, I'm gonna be giving a little bit of an advantage right from the very beginning to the state versus the defense? Anybody feel that way? Let's see, number 6, number 19, number 20, 48, anybody on this side? Alrighty, folks. So, does
Have 2
anyone
minutes.
know a victim, a close relative, or a friend of a victim who's been a victim of a serious bodily injury or a death? You know someone who was murdered, you know someone who was killed, and it was a criminal action, not an accident. Raise your cards. Okay, good amount of people. I'm sorry for that. Does anybody feel like for those who raised your card, you're starting out going, I'm already leaning towards the state versus the defense because of that person you've known in the past who's been a victim of a violent crime or who got murdered? Does that apply to anybody? Number 3, 22 through 24, 33, 34, 45, 52, 54, and on this side, 64. All righty, thank you, folks. We appreciate the honest answers. Does anyone feel like they can't sit on this jury for religious or moral reasons? Some people feel they can't stand in judgment of others. And if they're on this jury, while they could listen to the case, there's no way they could come up with a verdict of guilty or not guilty. Juror number 1.
All right, and for those of you who are raising your card, saying that for a religious reason you can't sit in judgment, the defense counsel is going to ask you from which, if it's biblical, he's going to ask for a biblical reference, and the biblical from King James version or whatever version it is. So be prepared to give him that. All right, you may continue.
Raise your card if that applies to you. You have a deeply held religious belief that you cannot stand in judgment of others. 34, 37, 22. Anyone else? All right, thank you, folks. Raise your card. Which one was it? 64. Thank you, sir. Lastly, folks, the court will instruct you at the end of this case that the presumption of innocence alone is enough to acquit the defendant absent evidence beyond a reasonable doubt of guilt after careful and impartial consideration of the evidence. All right. So what does all that mean? That means if the case is improved to you beyond a reasonable doubt, you only have one verdict to do, and that's not guilty. All right. So regarding the issue of guilt, how many doubts based on reason are required to vote not guilty? Are there doubts like 10 doubts? That's enough for a not guilty. No, I mean, the law says that if you have just one reasonable doubt based on the elements, the state talked about the things they have to prove. If you have one doubt about that, then you are instructed by the court, by the law, to vote not guilty. Okay, because the state has to be proven to you beyond a reasonable doubt. All right?
Council time.
I only have 4 more slides to go. But thank you, folks. We appreciate for the 12 jurors who are gonna be on this case. We appreciate your attention in this matter. Thank you.
All right, if everyone will wait out in the hallway, and people who have your personal items, you need to take those personal items with you and leave the cards behind, and then we will let you know who is selected on the jury.
Take your cards, I'll look for you.